David, you were talking today in your session about the European Court of Justice. Big question, I suppose, is the Spanish challenge, which is now sitting before the Court of Justice. What are your expectations about that? What's your prediction?
I don't make predictions, but I will pick up on some of the mood music that came out of the session, and I think the view is that Spain is likely to lose this particular challenge. But obviously we don't know, because inevitably the Court of Justice can be unpredictable.
And if Spain does lose it, what are the implications of that, do you think? And what do you think will come out of the judgment? I mean, maybe the judges, I think you mentioned, they might make some interesting points, whatever the actual conclusion.
Well, one of the bases on which Spain is challenging the regulation is that it doesn't have a sound basis in European law. And the Court of Justice might say, well, it does. And without getting into all the technicalities, one of the reasons it does is because the Court of Justice does have ultimate responsibility and overview of substantive patent law. So that might be the sort of quid pro quo. But of course, that creates knock-on impact, because of course, David Cameron, on behalf of the British government, said at the time that the reason he signed the agreement, one of the concessions he got, is that the Court of Justice wouldn't have a role to play, so wouldn't bog down the whole process. So there's a real tension there in what's going on at the moment.
And assuming the challenge doesn't succeed and the system comes into effect, of course, as you say, the European Court of Justice will have a role at the sort of apex of the proposed system. Are you concerned in any way, as some people are, about what role it might play and its involvement and experience in patent matters?
I think, as I say, first of all, I think it's important to emphasise we don't really know what the role will be. It's an organic, fluid process, in the same way that we haven't really only now really understood what the role has been for trademarks after some 15 years or so. If it does have a role, then yes, as a practitioner, I do have concerns. They've been expressed by some very eminent practitioners. Matters like delay, like the competency of the judges, like the clarity or lack of clarity of the decisions that are going to come out of the court. So these are all legitimate concerns that we have experienced when looking at cases that have gone on in relation to trademarks, supplementary protection, designs, and these sorts of issues.
And looking at the system as a whole, the Unitary Patent, the UPC, are you optimistic now? There's a lot of scepticism about it in the beginning, but now it's being developed. Are you more optimistic about how it will work, or less?
I was never desperately sceptical. I think that the Spanish challenge will, as we've discussed, probably fail. If it does, I think that will give impetus to the system. I think the concern is that, well, there's lots of things to be concerned about, but that's inevitable. Lawyers are conservative. We don't like change. I think that if we can keep to the overall program, which is providing swift, effective, cost-effective justice across the whole of Europe, then we will perhaps have a product that we can sell to the rest of the world that is equivalent to the sort of justice you get with US patents, Japanese patents, and that sort of thing. But it's going to take a long time.
Okay. Well, thank you very much.